Do we want to address Mr. Abel's case at this time, since he's here?
I think that's fine.
Okay. Hello. I had to go into my office today, deal with Yesenia and some other stuff. Everybody sent this to me a few hours ago, so I know I'm late to the party. I haven't seen it yet. Of course, Zach from Law Nerds Unite sends me a nice clean package. Thank you to everybody who sent it to me. I'm sure it's good. I think this is the soft sit who wears the Elmer Fudd hat. And I've got another fun one coming up here. Let's do it.
Mr. Estrada, do you want to join us? Missy, why don't you put Abel Estrada on there? Because I tend to read what's on the screen and then they don't.
Yeah, it's like I just called him Mr. Abel a minute ago.
Well, I called him Mr. Abel and then you used Mr. Estrada and then I noticed you went back to Abel. So I think if we have his last name on there, it'll help us keep it straight.
Okay.
We are on the record in the 13th Judicial District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal an illegal license plate. You apparently had a legal plate in your car.
Oh, I think I did this guy's whole trial. I mean, it was like a one-day thing. It's all coming back to me now.
But you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
Yep, there we go. But he's got the fake plate up there. Paul Dean was the attorney who handled the trial, and he was excellent. He was absolutely excellent.
This, Your Honor, this is the exhibit.
There it is. Thank you. And that was manufactured at your request by a private vendor. And you were found guilty and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. And then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file.
Judge, he's a soft sit. He don't need no stinking license. He does as he pleases. He's a rebel.
Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that. Notice of appeal, so you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond, and you did not pay that cash bond, did you?
No, I didn't. I actually did the properest, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted it. As soon as I got it, I submitted it to your office.
He didn't sign it. That's a day late, many dollars short, and insufficient in terms of procedure. Well played, Softset. Well played. Starting that appeal in style. I think there are big things ahead for you.
And then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason it didn't go, but if I get the signature, then I'm continuing. I'm doing it. I'm doing everything that's supposed to.
Well, I see you filed,
No, you see, you're not. You're not doing everything you're supposed to do. You're not doing anything you're supposed to do. let me amend your statement for you. Okay.
one page, it says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well,
That's different than the bond you have to post to appeal. One is a filing fee, one is a bond. They're two different things. I don't think you get out of that on a papyrus petition. I'm not sure. I'm not in Kansas. I'm just a simple country attorney trying to bang out a living in the Midwest, but not that particular neck of the woods of the Midwest.
apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of.
GZ, I do like that a lot better. That's got some style. That's got some flair.
If we don't have anything, I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case,
I see that.
if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or the initial complaint, you get a copy of it. Etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may,
Well, I show the journal entry of trial. Let me see if it was filed.
Paul's position is I don't care about his unintelligible gruntings. He lost. I don't have anything, to the contrary. I don't have notice of appeal. I don't care. Just whatever the next step is, let's do it.
February 21st, and that shows that he was found guilty of displaying unlawful tag. He was
I think he's still within his 60-day docketing time period. So
I think so too. So, Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
no, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me?
I don't think
I have my
you can.
glasses. I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really.
I can't track it. If you get in front of the camera and tell us your name.
Hi, my name is Annie Estrada.
Anna Estrada.
Annie Estrada.
Annie, A-N-N-I-E.
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front.
She went from Annie back to Anna. I mean, it's minor, but she did. Those are the things that bring me joy in life.
Of you with the Court of Appeals. Okay. If you'll slowly and loudly articulate that because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the,
That's the
That
pertinent
part.
part.
Okay.
Body of the letter, where
Okay.
it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in forma pauperis, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance. That's all, Deputy Clerk.
Thank you, Annie. I am going to respond to that with my own Annie. I actually have one ready, and it's perfect for this scenario. Annie did a nice job reading that letter. We understand. And then my Annie's going to translate her reading of the letter.
all right, so you have not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
I'm liking Paul. Judge knows she's not supposed to help him, but she might do it out of instinct. This is what happens when you're an attorney. It just bothers you. I'm probably in anything, but certainly I'm an attorney, so I feel it that way. Whenever you're trained in anything, I suppose if you're a doctor or whatever, you see someone flailing around just doing something horribly, you're just like, oh, for the love of God, stop thinking, shut up, give me the paper. This is what you need to do. Now go away. That's your instinct as an attorney. And Paul knows that Judge Webster might do it, and he's reminding her, hey, it'd be inappropriate for you to sit here and tell him how to fix all of his deficiencies right now. Don't worry, Judge Webster. The appellate court's already laid it out for him in that letter.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you filed with the Court of Appeals. They specifically
Don't interrupt him. Let him finish.
They specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability.
He did ask him, earlier in this hearing, and he did say I didn't send it to you. now he's changing fields on that. like our memory doesn't last 2 minutes.
But Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, it does it. I don't know.
It is nonsense. That was your argument. That argument is sufficient. That's all that needs to be said. I concur.
You know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform and under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby denied.
Yes.
And let's see, journal entry of continuance. Did you file that?
I think the journal entry of continuance, Your Honor, may be the last one where we're reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
And the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May. It hasn't been properly completed at that point in time. The state would be moving to dismiss.
Yes, kick it till after May. Check to see if he's fixed his deficiencies. He has till April 21st. He very likely won't because he can't figure it out. Then you just say, all right, your license is popped again, and we'll go from there. He'll drive, he'll get picked up, and he'll get thrown in the clink. That's what'll happen. In the unlikely event that he figures out how to get an appeal going, that may extend things, but his appeal has no merit, so he'll get whacked and lose the appeal. But he's not going to do it because he has to pony up a bond for the amount of the sentence, basically, in order to appeal. He's not going to do that, and therefore this thing's going to be dead on April 22nd.
The appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything. So I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigence, which you already have, and then the request for the records. I already sent it in, and I said that.
Yeah, Annie strikes me as a sweetheart. She really does. I don't know how he got lucky with her, but she strikes me as a sweet woman who's really good to him. He doesn't deserve it, but there you have it.
So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, do I need to send one directly myself, or do you get a copy? And I'm telling Mr. Dean, the judge and Mr. Dean gets a copy, and they say, no, don't worry, they get a copy. So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record.
Who is the court of record? Is that the district court? Is that the
District Court.
Court of Appeals? Did you send it to the clerk? You sent it to the judge?
I send it to you directly, magistrate, and I send it, I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also.
I don't know what he means by court of record. And that's a bad sign for him. That's a bad sign for him. Maybe it's something I haven't heard of, but I don't know what the hell he's talking about. And I've been doing this for a while. If you have something for the appellate court, you better send it to the appellate court with a copy to the prosecutor. If you have something for her, you need to send it. You need to send it to this district court with a copy to the prosecutor. He can't answer where he sent the stuff. I doubt he sent it anywhere.
That's why I submitted this already.
Okay, order to remove the document should not be filed. I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time. And it was premature. You shouldn't have filed that. So that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the file. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can,
Agreed. The court system absolutely sucks. But I will tell you, it beats the alternative. Try living in a society without one. Just give it a shot.
see, there was a paper. Let me see. Let me go see what it was.
See if it's at the clerk's office. But as far as the informa pauperis, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney. And you
Of
fired
course.
that attorney, and then we appointed another one, and you didn't want to use him. But as I recall, you do have a monthly income. And remind me, does your wife work?
No,
Okay, well, I have never seen, I've never made that determination. And I'm not inclined to make it at this time. You do get some income, as I recall. And if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the filing fee.
I'm requesting the papers because it'll cover it. And then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request. And all I need is the letter that I submitted, which is, for some reason, they're asking for you to sign, so
Perfect, Abel. You got this. You got this. They told you everything you need to do. You roll with that. We'll see you sometime after the 21st, okay?
I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to, the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court.
Oh, I see. Paul is thinking the same way I am. Pretty much exactly.
That's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that Dylan, we've received his copy of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge Webster, and their addresses, and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
All right, Missy, what do we have in May?
I know the perfect judge. I know the absolute perfect judge for this scenario who knows exactly what to say. He's right here.
Why are you unnecessarily wasting the judicial time of this court?
We have May 9th. I think that's the only May date we have.
Okay, at what time? 11?
11.
All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear to May 11 at 9 a.m. You're either going to have that paid, and cover all of those matters that the appellate.
Oh, what I would give to see this guy's performance in front of that judge. I don't know. I think he's in Gujarati or Calcutta or something. I don't know where. But I would pay money. I would pay money for him to come in on this motion in front of that judge. Oh, it would be an absolute bloodbath.
Court is listed, including paying that appeal bond, also known as a supersedious bond, that needs to be paid.
Yeah, Paul's excellent. He's crushing it here. He's doing a great job.
Of 158 cash. So.
May I ask a question?
Go ahead.
Yeah, I just need to know if you're going to sign the forma pauperis letter that I sent you.
I'm not signing that at this time.
That would be holding justice from me.
Well, so you believe, you also believe my decision was holding justice from you. That's my order at this time. I'm not going to sign it. And I'll take your pay or appear up at the date and time given.
Well, there's a particular procedure that you need to research on how you go about making that request to the courts. You don't just send a document saying, "Fine, make this finding," without support. That's not the way court works. Your Honor, I'd ask the court to go ahead and approve this journal entry since these documents will be needed, probably potentially supplemented to an appellate record. Mr. Estrada, if you agree that this is what we did today, then you can say yes, and I'll put an S/ showing that you approved it. If not, Your Honor, if he's objecting, instead of going through the whole lengthy Rule 170, I just ask the court to approve it if it agrees. This is the case caption, case number, the date that we all appeared, that you appeared, or that Judge Webster was hearing this matter, that you, Mr. Estrada, appeared via Zoom, that this case was set over to May 9th at 9 a.m. And it's, set over as a continuance. It's not granted, or time's not charged to any party because this is on appeal. And that it's set over regarding pay or appear and or completion of the docketing. Oops, I need to finish putting on statement. Completion of the docketing statement. X on that box, and there's no need for it. And there's nothing else.
Because your petitions, whoever has drafted it, they don't know how to draft it. draft the petition properly.
I'm sorry.
I guess I should have put that the motion to dismiss liability was denied.
Yeah, but that is denied.
That must have been what I was planning on, and then we got to discussing some other issues.
And you might put in there that the defendant needs to either pay or post his appeal bond and perfect his appeal, something to that effect, by that next court date.
And that was 11 o'clock on 5/9, right?
Yes, I was gonna ask about that. The
Oh, I had it. Okay.
Missy said 11.
All right, I'll get that changed to 11.
I wonder, Missy
Yes.
no, just leave it there.
All right, if we can do it at 11 if you want.
No, that's fine. Whatever you have.
So it's a 9 o'clock or 11 o'clock?
Whatever Missy says, that's what we're gonna go with.
I've now changed it to 11. I thought that's what everybody wanted.
Okay.
Okay. So change that to 11 a.m. And then Your Honor went ahead and added what we just discussed, that the motion to dismiss liability is denied, and further that he needs to complete the docketing of his appeal. Complete the docketing of his appeal, pay the appeal bond, or pay the case in full by the next court date. Mr. Estrada, do you agree that that's what the court just ordered?
I hear what you're saying.
Your Honor, I'd ask the court to approve.
Approved. I understand you don't agree with the orders, Mr. Estrada, but they are what I ordered.
I'm simply on the defendant's signature line going to mark approved over defendant's non-response to the correctness of the order. Accuracy of the order, I should say. All right.
We got you.
I'll submit that. Is that acceptable to the court, Your Honor?
That is acceptable. There's nothing further. We'll be in recess on this matter, and Mr. Estrada is excused.
Thank you.
Thank you.
Court does call the case, Westbourne Family Trust.
Oh, I forgot about this. I just got this. I got to look and to see who credit. I think I'm not sure. It might be Iris's fault. Let me see. This guy's pro se in front of Simpson. Woo, it's rough.
Versus Daryl West.
Mark Land on behalf of plaintiff.
Mr. West, state your appearance. Just state your name. You got to unmute first, sir.
Confirm this is Iris's fault. Please direct all comments and complaints to Iris.
Daryl West, present.
Okay, where are we on this case? I'm afraid to ask.
Judge, this is a termination of tenancy action. My client is the owner of property. Mr. West is the trustee and the trustee's brother. He's been living there a lot of years, and they are estranged. And my client just wants to get the property back, sell it, and that's pretty much the long and short of it.
It's not the long and short of
All
it.
right. Well, I've read everything that you submitted, Mr. West, much of it irrelevant to these proceedings, quite frankly. The only thing that I have that maybe...
It's not the long and short of it. Let's do it. Let's do it. Iris told me this, and she was right. She was right. Where are we here? It's
Any objection? All objections.
Be of some relevance. Is there a matter pending in the Court of Appeals?
Absolutely. Case number 375000.
Your Honor,
375.
Mr. West filed a motion to stay the eviction case that was denied.
That's not
Oh, in the
exactly
Court of
correct.
Appeals?
It was denied with the Court of Appeals.
All right, thank you.
Judge, that's not exactly correct. It's a misleading statement. Actually, what happened was filed an interlocutory appeal, and the circuit court went ahead and ruled while that interlocutory appeal was pending.
Any objection, Mr. Miller?
I actually object to everything he's doing.
Therefore, I filed a right of appeal and let the interlocutory appeal be dismissed. And it was on that basis that the interlocutory appeal was dismissed based on the current pending case. And there's still on the docket a motion.
But there is no stay of these proceedings.
There is a motion for stay of these proceedings on the 375000 case.
All right. Well, you're going to have to get to them because I don't see here that I've got a tribal issue. I am not going to stay these proceedings. And so if the Court of Appeals wishes to stay it, then the Court of Appeals can stay it. Mr. Landau has indicated that they denied it. You're indicating something different.
Am I entitled to a
that stay may just be moot pretty soon.
jury trial?
If I don't have a tribal issue, no, sir.
Judge, there's promissory estoppel, there's quantum meute, there's a written documented contract documented and subscribed by the plaintiff.
All of those are not tribal issues that grant you possession of the premises, sir.
The document subscribed by the plaintiff grants me premises occupancy.
I disagree. It's not a tribal issue for me, sir. You show me nothing that gives you claim to those premises.
Which is number one, wrong.
I submitted the document where the owner of the property granted me living arrangements to the property. That's in the file.
For how long, sir?
For the balance of my life.
I do not see anything in here representing a life estate. If you are claiming that you have a life estate, then you need to file the appropriate paperwork.
It's not a life
circuit
estate,
court.
Judge.
You need to file the appropriate paperwork in the circuit court so the circuit court can make a determination as to whether or not you have a life estate of some type on the premises. But I do not see that. I do not see any defect in the notice which has been provided by the plaintiff in this case. I have nothing to try.
Please address their complaint. Their complaint clearly files misleading information. In item 2, counsel says there is no other pending or previously filed document or court actions. And in fact, there was a circuit court action and it's under appeal now. Therefore, that's misleading statement. Furthermore, in
Which has no relevance to this court and its decision. Because this case would not have gone up to circuit court.
this case was already in the circuit court on a parallel.
No, sir. This case is a district court case. This case regardless of what plaintiff said, would have been filed and resided right here before me.
Judge, can I go on further to the complaint?
Not if you're going to waste my time.
I'm not. In
Yes,
Section
you are,
8,
but go ahead.
in Section 8,
Yeah, you are. Why do we enjoy Judge Simpson's pain so much?
plaintiff and counsel suggest to this court that the property owner has maintained that property in accordance with state law as it's a residential unit. That is absolutely a false statement. She has stated in a statement of facts and a motion at the circuit court that she hasn't communicated or been in contact with the resident occupant, Daryl West, in 10 years. She has not maintained the property in accordance with Michigan law. Furthermore, because I had to maintain it, I spent $25,000 of my money to keep the property maintained. She has completely falsified the complaint, Judge. She did not provide.
Like all these people. Well, then that's perfect. It's time for you to go to some place that you don't have to maintain and just pay rent there. That'll be great.
Adequate maintenance to the home in reference to Section H of the complaint. That's a false statement. There's two false statements provided in the complaint, and the court should order a show cause hearing at the very least and should actually dismiss this case.
Are you done?
Yes.
It still is not an issue related to the termination case. If you believe that there's a money case that needs to be filed, then you may do so.
Judge, one last point.
I thought you were done.
I was until you made that comment.
I was, Judge, until you were all naughty and had to express a reasonable thought. Now I've got more stuff to say. It's like arguing with a girlfriend, except he isn't cute. Poor guy.
Sir, I might suggest that you get yourself an attorney to represent you.
Can you adjourn it?
Because the termination case, nothing has been filed before me that gives me anything to try as a reference to termination case. I'm going to keep saying it. There's nothing that you're saying to me right now. I've let you go on far longer than I would normally let anybody else go on regarding this. If you have one more thing to say to me, you may, and then I'm going to have my word.
Have your word, Judge.
Court finds that there's no tribal issue as to the issue of possession in this matter. I will grant judgment to the plaintiff for possession with a writ to issue in 10 days.
As much as I appreciate the court making that ruling, I'm willing to give Mr. West additional time. My client is his sister, and even though they're estranged.
Oh, sweet Jesus. What?
She knows that this is going to create a hardship for him.
Look at Judge Simpson. He's like, really? No, you're going to start this crap? I get it. The guy makes an impassioned plea. He says he's an amputee and we don't want to put him in a bad place. And I get all that. It comes to a nice conclusion. Judge Simpson does the only reasonable thing and handles it, but it is a funny moment still. I mean, I feel for this guy. That's the thing. Like, I could have empathy for him, but he comes in like so obnoxiously that he takes your empathy before you get there.
He is an amputee, and it's going to take him some time to vacate. I want to give him the comfort some additional time.
So here's what I'm going to do, Mr. Landau. I understand that. So I'm going to issue my judgment. What the parties work out, you can work out. But I'm going to issue the judgment as I pronounced.
Very good.
Thank you.
I'll submit the judgment.
There you go. That's what I got. That's what I got for happy hour there. That's good. It makes all the sense. I don't know why I get it. It's a sister brother. They feel sorry for him. The guy's cranky as hell. Nobody wants to deal with him because he's unpleasant. But they also feel sorry for him. They're like, oh, I don't want to make him homeless and all this stuff. I understand that. The judge is like, all right, then wait to come in on to get the writ issued. Like, we're going to do the judgment today. And then that just puts the ball in your court when you want to kick him out. You don't have to kick him out immediately, but the judgment's sitting there. So when you want to later, because he won't leave. So if he says, I need a month to get another place or whatever, then you can just wait to do that. You don't need judicial involvement on that. You sort of just delay execution of the judgment in that sense. Execution of the judgment here is going to is to have a writ issue to have the sheriff go and throw his ass on the curb. You can do that at your own discretion after judgment is entered. You could wait 6 months if you want to. So that's all it is. I think that guy just wanted to go on the record after he won. I think he wanted to go on the record and be like, well, I'm still a nice guy. And like, I get it, but just take your judgment. Shut up. Literally, what's the alternative you're asking him to do? To not take a judgment? To take some sort of conditional judgment? To say, you know what, I'm going to take a judgment in 3 weeks? It's not how this works. I don't know what he was asking for. It's a minor point. He's a sharp attorney. There probably is something he was asking for, but I'm just saying off the top of my head, watching this hearing, I'm like, that makes no sense. He had something in mind that did make sense. But I'd be the same as the judge. I'm like, no, we've done this. I'm doing that. God forbid he gets the appellate court to say, oh yeah, we need a stay, 3 weeks from now. Right now, there's no stay pending. He can do an order. There's a judgment on the issue. Now, if they stay it, okay, fine. You stay those proceedings post judgment. Fine. The ultimate irony in that is if his motion for a stay is granted, that now cements the judgment because now he has to lift the stay to get it. Nobody knows what the hell I'm talking about. Don't worry about it. Forget it. There shall be no more talking about law on Law Talk with Mike. It's just law talk. The actual law talk is accidental. I got really crazy with the other day. I was not awake yet. I apologize to everyone for that. If you had to see, it was at the end, so you already got to see the clip. So if you can, go ahead and skip it. I don't know which stream it was, but I did too early in the morning a stream and then started making law gruntings that nobody liked. Thanks for coming out. Behave yourselves. I'm not bailing you out.